Thank you, Giorgio, for your very interesting and concise summary of the proceedings in Genoa. And now we have our keynote speech by Professor Måns Jacobsson. He doesn't need any introduction. I think he has been delivering us some of the most precious and interesting, at least as far as law is concerned, bits of this conference in his keynote speeches all over the year. Then these speeches get published on very important reviews, and I think it is also good that apart from the video recordings of our proceedings, we have got something on print so valuable that perhaps you rework them and extend. And I so hand over the floor to Måns and thank him for being with us this year and in the years to come, I hope. Thank you. Oh, sorry. The title of his keynote speech is compensation for pure economic loss in relation to tanker oil spills. It's not so bad. I think they're always very interesting. It sounds, the title, a little bit how do you say, complex, but then it flows very gently into our minds. Thank you.
Thank you, Francesco. As all of us, we are very pleased and honored to be here, and seeing also how Francesco manages to lift the conference from a venue point of view for every year up, and I wonder where he can go from here now for the next year. Yesterday it wasn't very much. The title of the conference is Shipping and the Law. Of course, yesterday it wasn't that much law. It was shipping and policy, and not only shipping policy. Today, I think, with Giorgio Berlingueri, we have started to discuss legal issues. That's what I'm going to do. I will address a very particular question, that is compensation for pure economic loss. As you know, a tanker oil spill may result in considerable damage of many types. You will have damage to property, you will have costs for cleanup at sea or on the beach, you will have loss of income by businesses and fishermen, and you will have environmental damage. And I will only speak about the economic loss point. Why is that important? Well, of course it's important for those who suffer losses as a result of a tanker oil spill. These innocent victims, fishermen, small businesses, get compensation. But I think it's also very important from the point of view of the image of shipping, because you all know that after a major oil spill, there is anger, there is frustration in the local community. Politicians react very badly. And if at least the most vulnerable people, small businesses, can be compensated properly and fast, that will probably, at least to some extent, reinstate the image of shipping. So that's why everybody in shipping has a certain interest in that. Giorgio did refer a little to the two treaties that govern compensation issues in relation to tanker oil spills, the 92 Civil Liability Convention, the CLC, and the 92 Fund Convention. And they were earlier preceded by conventions with similar names of 1969 and 1971. And then we have also a newcomer, and Giorgio referred to that, the Supplementary Fund from 2003. Under the CLC, it is the ship owner that has the strict liability for any damage caused by the escape of oil from his ship. But he is normally entitled to limit his liability to an amount calculated on the basis of the tonnage of the ship. This is, of course, traditional in maritime law. He will have to cover his liability by insurance, normally within one of the P&I clubs, and in most cases, a club within the international group, and I know that some of the club representatives are here today. If the amount available from the ship owner and the insurer is insufficient, then the International Fund of 92 and previously of 71 step in and provide additional compensation. The funds are intergovernmental bodies governed by bodies that are composed of representatives of the governments of the state parties. Now, turning now to I must also mention that in any major spill, claims are handled jointly by the funds and the P&I clubs, and the fact that the regime has worked reasonably smoothly is due to the very close cooperation between the clubs and the fund. Now, turning to economic laws, there are, from a legal point of view, basically two types of economic laws: consequential economic laws and pure economic laws. Person whose property has been polluted may also suffer economic losses. Let us say a fisherman whose nets or boats are polluted and he cannot fish during the time that his nets are cleaned or being replaced, and he loses lots of income. That is consequential economic loss, and in most jurisdictions, claims of that kind are admissible, and they have always been accepted also under the international treaties that I mentioned. But then we have people whose property has not been contaminated. They may also suffer losses. You will have a fisherman whose nets and boat were not polluted. He may have been lazy, he didn't have them in the water. But he can't fish because oil is all over the place where he normally fishes. He suffers loss of income. Or take an hotel owner whose hotel is located on a beach, but it's a public beach. He doesn't own the beach. If the beach is polluted, there are no tourists there, and he suffers economic loss. That is what is called pure economic loss. And there the situation is a little more complicated. In most common law jurisdictions, courts have been very reluctant to accept claims of pure economic loss because of a fear of the far-reaching consequences that it would have to accept them. And this is a position that has constantly been taken by the United Kingdom courts. Claims for pure economic loss are just not admissible. Some other common law countries have the same position, India, Nigeria, for example. The United States also honors this principle, with one exception, and that is oil pollution. After the Exxon Valdez, the American legislation, the OPA 90, allows pure economic loss claims for oil pollution, but oil pollution only. New Zealand, Australia, and Canada, in principle, follow the United Kingdom approach, but they have been a little more flexible in recent years in this regard. When you then turn to other jurisdictions, non-common law jurisdictions, the situation is actually quite unclear. In some of these countries, economic loss is not considered a special type of damage, but is a damage like anything else. And this is the position generally taken in the countries whose legal system are based on the French tradition, the Code Civil, the Napoleonic codes. And they then look at, they have a criteria of forcibility, remoteness, or require that there should be a direct link of causation between the pollution and the loss. We have, as an example of that, France, Belgium, Italy, don't forget, and Greece, Netherlands, Spain, but also countries in Latin America, and surprisingly enough, Denmark, Norway, China, Japan, and Korea. But there are also other countries in the civil law system that have a different approach. In Germany, for example, pure economic loss is only rarely accepted, and that is the case in Sweden and Finland. And in Turkey, such claims are never admissible at all. Now here, of course, the fund was, the 1971 fund, the old fund, was confronted with this issue already in the 1980s in connection with an oil spill in France, the Tanniu. And then later, a great challenge was to deal with the claims arising out of the Haven case that occurred off Genoa in 1991. And that resulted in pollution from Genoa up to the French border and beyond in France, all the way up to Toulon. And the fund then received, together with the P&I clubs, 1,000 claims for pure economic loss from hotels, restaurants, beach facilities, so-called banyies, and all sorts of shops. And here the fund had a real problem. How to accommodate the difference between the position taken in the common law jurisdictions and those in the civil law jurisdictions, because the paramount concern was, of course, that in the fund system, all claimants would have to be treated equally, independent of in which country the damage occurred. Now, in the early days of the operation of the system, the decisions on claims were taken, the problems were solved as and when they arose. But after major spills like the Haven, the AD Abruzzo, and the Patmos in Italy, and the Aegean Sea in Spain, and the Brer in the United Kingdom, the governing bodies, the governments, thought that it was time to take a more systematic approach to these kind of things. And in 1994, after a very, very extensive study of this, the fund adopted certain criteria for the admissibility of claims, and in particular, claims for pure economic loss, because it was thought important for the stability of the system, and would also give a more of a foreseeability from claimant's point of view, whether or not a claim was likely to succeed. Now, the problem is that the conventions do not explicitly say whether pure economic loss is admissible, but the funds have tacitly always accepted them as admissible in principle, because the convention only says loss or damage caused outside the ship, and that doesn't make us very much wiser. And certain criteria were then developed, and the main criterion is that there should be a sufficiently close link of causation between the pollution and the loss. It's not just because there was an incident that's enough. The analysis starts with the pollution, not with the incident. Now, it should of course be remembered that these criteria adopted by the fund governing bodies, by the governments, are not binding on national courts. Because if an agreement to settle a claim cannot be reached between the claimant and the fund and the clubs, then of course it is for the national courts in the various states where the damage occurred that have the last say in how the convention should be interpreted. I come back to that. Now, it was said that there should be a sufficiently close link of causation. And what does that mean? When the fund, as it went along, developed certain criteria, firstly, the geographic proximity, how close was the business with the pollution? To what degree was the claimant's business dependent upon the affected resource, the beach or the seawater? Could the claimant do something else to remedy the situation? For example, a beach hotel could perhaps try to get a legal conference there instead, and by that offset his losses. And looking also at to what extent is this business an integral part of the economic activity in the area affected by the spill. When the criteria was adopted, it was also emphasized that it should allow certain flexibility to the fund in the light of new claims and new situations, and this has indeed been the case. Now, after the adoption of these criteria in 1994, the fund has dealt with tens of thousands of claims for pure economic loss. And this, of course, has led to that these criteria being developed and refined, but basically the criteria adopted in 1994, more than 20 years ago, still form the basis for fund policy. Now let us take some examples here, because there are a number of people that are affected by an oil spill. In the fishery sector, for example, it may not only be the fishermen that are directly concerned, but also fish processing plants and fish sale companies around the port where the fish is normally landed. And they may suffer losses if they are deprived of their normal supply of fish. Then one has to look at, as I said, where is this fish processing plant located in relation to pollution? Can it buy fish from elsewhere? How closely linked is it to the other economic activities there? And you make the final approach on what is a reasonable link of causation here. In the tourist sector, it's a little different, because there you have an owner of an hotel located on a public beach. And of course, if the beach is polluted, the guests don't come there. And also the restaurant in the hotel will suffer losses. But this may, of course, result in there will be fewer napkins, sheets, and tablecloths sent from the hotel and restaurant to the local laundry. So also that business suffers losses. And the hotel restaurant will buy less meat from the local merchant, who will buy less meat from the wholesaler, who will buy less meat from the butcher, who will buy fewer cows from the farmer. And all these could say, of course, that, well, if it hadn't been the oil spill incident, we wouldn't have suffered these losses. Should also all these be entitled to compensation? That is what the French say, dommage par ricochet. Now, in the tourist sector, the fund has decided, and it's a policy decision, and I must admit that I was largely behind that there is a distinction between two categories of claimants. The first one is those who sell goods and services directly to tourists, for example, hotels, campsites, bars, and restaurants. The second category are those businesses that sell goods and services to other businesses, who in their turn sell it to tourists. For example, wholesalers, manufacturers, souvenirs and postcards, and hotel launderers. And it's been considered by the funds that this second category, there is not a sufficiently close link of causation between the contamination and the damage. And they will therefore not be entitled to compensation. And when these claims that have been rejected by the fund and the clubs have been pursued in courts, largely with few exceptions, the courts have agreed that these claims should be rejected. Now, one must of course remember that one problem with the claims in the tourist and fisheries sector is that there are great variations in the economic result in these sectors from year to year anyhow, for reasons that have nothing to do with oil pollution. So one then has to compare the polluted area with the development in similar businesses in other parts of the same country. For example, if there was a rainy summer one year, tourists may decide to go to Morocco instead to the French Riviera. And that, of course, has nothing to do with an oil spill. Now, the definition of pollution damage also says that pollution damage includes reasonable measures to prevent or minimize pollution damage. That's what's called preventive measures. Now, it is likely that the drafters of the convention thought of physical prevention of physical damage, damage to property, and pollution of the beaches. But here the funds have gone further and also accepted the cost of reasonable measures to prevent or minimize the impact, economic impact on, for example, fishery and tourism. For example, the 71 fund accepted to pay for a claim by a salmon farmers association of Shetland, who sent people to Japan to a big fish fair, because Japan was their most important fish market. And it was important after the Brer oil spill to convince the Japanese fish buyers that Shetland salmon was safe. And they succeeded. Now, a very contentious issue has over the years been how to deal with claims for losses suffered by employees who have been laid off, made redundant, or had their working time reduced as a result of an oil spill. The fund policy here was adopted after a number of big spills, starting with the Aegean Sea in Spain and the Brer in the United Kingdom. And it was decided that the losses suffered by these employees is normally one step further away and is therefore not considered being sufficiently close to the pollution. But the position taken by the fund here has been actually quite heavily criticized over the years. And then early in 2017, this year, the Korean Supreme Court rendered 3 judgments where claimants of this type that had been rejected by the fund were accepted by the Korean Supreme Court. And this was reported to the governing body of the 92 Fund at its meeting in April of this year, and it was decided that in the light of this judgment, the fund policy should be reconsidered. And the director of the fund, my successor, was instructed to make this study in a document that will be considered by the Fund Assembly at the end of October this year. The director proposes the fund should change its policy here and should be prepared to accept losses suffered by employees having been laid off. But there are a number of conditions to that. Firstly, the so-called ex-employee must have actually been employed when the incident occurred, and not only have had an expectation of employment, which of course in the tourist sector is quite usual. The second is that the ex-employer's business must also have been affected. The time for the payment of compensation to the employees or ex-employees cannot exceed the time for which compensation is paid to the employer. And finally, if the victims have received social security payments for being laid off, then that should be deducted from the compensation, because otherwise the redundant person would actually be paid twice for the same thing. Now, of course, this change of policy will have a significant impact on the international compensation regime. If you just think about an incident in Italy in the beginning of the tourist season, say up in the coastal area affected by the haven, that is the Italian Riviera, there may be tens of thousands of employees being made redundant for a number of months, perhaps for half a year. And that could result in enormous amount of compensation to be paid to these people. Now, this would have been all fine and good if there was an unlimited amount available for compensation, but there is not. There is a specified amount available at present for Italian purposes, $1 billion per incident. And if all these redundant people were being paid compensation in a big oil spill, that may result in not sufficient money being available for other claimants. And all claimants are treated equally, so they will all get a reduction in percentage of their claims. So it will have a political and financial impact beyond these redundant people. Now, trying to draw some conclusions from this, I think it's quite an extraordinary achievement that a number of states, today over 100, with very different legal traditions and very different economic and social development, have been able to agree on criteria for the admissibility of claims for pure economic loss and other losses, which could be politically very controversial. As I said, the national courts will have the final say, but the fact is that national courts have largely accepted the fund's position taken to reject claims, and it's just in extraordinary cases like the Korean Supreme Court I just mentioned that the courts have been accepting claims that have been rejected by the fund and the clubs. And this is, of course, shows that it's important that this international regime works under the supervision of the independent judiciary in member states. So I think one can say that the system will work reasonably well, and one evidence for that is that when the first fund was set up, there were 14 member states. Now there are 117. And if we assume, which of course is by no means sure, that governments act rationally, then the fact that so many states have joined the system tends to indicate that governments have considered it is worthwhile for the country to do so. But law is not static. Law is not cast in stone. It has to develop to take into account changes in society, changes in political and economic concepts. And this, of course, applies not only to national laws, but also to international treaties. And that is why I think it's important that in a system like the CLC fund regime, the governments of states within the fund bodies are prepared to reconsider the positions taken by the fund when the development, the experience of major oil spills show that it is justified to do so. Now, against that, of course, stands another very important consideration, stability, that there should be a consistency over time in the position taken by the funds, the same as you have in the court system, where stability in the legal position should in principle be maintained. So it will be very interesting to see what the fund governing bodies will do with these proposed different criteria for admissibility of claims that from claimants that have been laid off in the tourist season as a result of an oil spill. And we will probably know that in a few weeks' time, but I will not even try to say what that will be. Thank you very much.